Good afternoon. Thank you. You may be seated. We are here today in the case of Vicente Ruben Martinez versus Cynthia Marisol Gutierrez. It's our case number 1CACV150861. Each side will have 20 minutes for argument. Appellant's counsel will be responsible for reserving any time you'd like for rebuttal. These proceedings are being audio and video recorded. We would request that you announce your name when you come to the podium and state who you're representing. We have conferenced this matter. We've read the briefs that you've submitted and have reviewed the record, and we hope we're familiar with the record and the arguments. And with that, we look forward to your argument. You may proceed.
Good afternoon, Your Honors. Joseph Charles, on behalf of the petitioner, Vicente Martinez. Thank you for the privilege and honor of being here in front of you. It really is an honor. There's seldom that the court has the opportunity to correct a gross injustice, but quite frankly, this is one of them. Because at the trial level in 2013, when Judge Foster took this case on, the court was misled and misguided and quite frankly lied to by the respondent in this matter. Now, sadly, as most people on the street know, and I apologize, I don't know your all's background, that there's more perjury and lies on the 5th and 6th floor of the building at 201 West Jefferson than there is anywhere else. Nowadays, 80% of the cases in the family law courts are handled by pro se individuals. So a trial judge has a huge responsibility of he said, she said to try to resolve a case. You have children, you have property, you have all types of issues there. And quite frankly, there's not a large amount of case law to say what does a trial judge do when they find open and blatant misrepresentation, or as I suggested in this case, lies that are presented at the trial level.
All right, Mr. Charles, let me ask you a couple of questions. So, with respect to this first proceeding in front of Judge Foster, he obviously made some credibility determinations, made some findings of fact and conclusions of law. Those became final, didn't they?
Those became what?
Final?
No, no. And we've I'll get to the Bates decision. And anytime there's a fraud perpetrated on the court.
Well, let me ask my next question then.
Okay.
So the next question is, did your client ever move to set aside that decree on the basis of fraud?
Only when he learned, basically, he never learned of the facts, Your Honor, till after the petition for modification. And I'll kind of color what happened to him so he didn't know in the short history I'll give you in regard to it. But in concluding my opening, what I was trying to suggest is this decision, if communicated to the legal community, could ring some bells and give some guidance to what's happening just down the street here. And I will try to answer your questions concerning that. Vicente, the father, was certain that the mother was, in fact, going to Mexico and would possibly live there. But he couldn't get, if you read the briefs and understand what Judge Foster was under, he couldn't get the passion of that argument, could get nowhere because the mother kept saying, no, that's not true. Now, you remember she was carrying a baby. At the time of trial, she was 7 months pregnant. The father was living at Rocky Point, National from there. And she was still making this facade that she lived in Buckeye, even though her mother's home was next to Vicente's, very close to his home. And so the exchange of the children went there. He had no idea what was going on. And then to carry the fraud further, Your Honor, is you remember Judge Foster's order, because he obviously, in this day and age, most these parenting agreements are pretty much liberal with the fathers. Arizona is one of the best states in the union for that. This case shows a somewhat every other weekend and 2 hours on Wednesday. Now, would any reasonable trial judge have the mother come from Rocky Point or Mexico 2 hours up to Phoenix for a year or so period of time? Because you can't do anything for a year in regard to a family law case under these circumstances. Well, of course not. But the trial judge was under the impression that the mother was telling him the truth.
But didn't she in fact do that? Was there an allegation that she didn't comply with the parenting time order?
He went to a parenting coordinator, in fact, of an attorney in Glendale, and asked for help because he wasn't even getting that. And the parenting coordinators were kind of limited what they could do, but the mother still was attempting to keep this facade for a while, that she was in Arizona. They would never communicate with each other. The emails did not show that she was emailing. Because I've asked, well, how did you not know? He had to hire a private investigator. It was about the time she filed a petition for modification in April of 2015 that it all flushed out that really I want to live here. Now, as you know from the brief, when we questioned her at the hearing and on her deposition, she admitted the decree was signed in February of 2014. She admitted, February 2014, she admitted in March of 2014 that she was residing in Mexico and that would be her primary residence. That was a fraud on the trial judge that just heard the case 90 days earlier, Your Honor.
Yeah, I understood the first, Judge Foster's comments seemed to me to be more directed to whether she was intending to abscond and kidnap the child and go to Mexico, as opposed to she may have, what if she had just moved to Gilbert or to Tucson? If there's parenting time, it seems like your client would have the option of filing something to say she's not complying with the parenting time order. It isn't so much I need to know exactly where she's living. If I'm putting myself in Judge Foster's position, it's a question, if I don't have any kind of motions or something being filed saying she's not complying with the parenting time, I don't know why he would necessarily care where exactly she is.
Well, of course he should care, because he's got to fashion an order of how are two parents going to have time with a child. Now, we get these cases now where the mother will say, I'm going to go live with a serviceman in Austin, Texas, or San Diego. So now the trial judge can fashion.
What if she's thinking about that, but she's not sure? Do we have to know exactly what she's thinking? And is that really a necessary part of that initial order?
Well, that's what the people in the trial level are going to tell you, meaning the litigants. What I'm showing you here with this temporal distance looking back, how the judge was deceived and lied to about what she was doing. In other words, Vicente brought up, she's going to Mexico. I know she's going. Now, he thought possibly to abscond. He didn't think anybody. She had parents here. She had other family members here. He never thought for a moment she would permanently live there. But lo and behold, that's the subterfuge she did. And she had the intention of doing that within 30 days of the divorce decree being signed.
Right, Mr. Charles, I want to circle back to the first question, which is, there was no motion to set aside the decree on the basis of fraud.
John, you would have to. Are you suggesting I should file that now? I mean,
I think it's too late to file anything like that now.
Of course it is, because number one, Vicente was under the masquerade that this wasn't a permanent, and when she does file the petition.
Well, what you're suggesting is, giving everything you're saying, taking it as granted, you're saying your client learned of this.
Sure.
But he did not move to set aside the decree on the basis of fraud.
Once he learned of it, at the same time he learned of it, but through a private detective, in April of 2014, 15, that's when the mother filed just a little over 1 year from the decree. So she had this systematically spelled out what she was going to do. She hired an attorney to file. So whether or not I question the terms, Your Honor, of a fraud to set aside decree, we made it clear to the lower trial judge that this was a fraud on the court.
But you didn't make it clear. There's no allegation that he was not or that mother was not complying with the parenting time arrangement. I don't recall any.
No, you're absolutely right, because she would drive up here.
But so why isn't that the most important aspect of the original order? And if the parenting time is being complied with, whether she lives in Gilbert or Glendale, why would we want to go beyond that? And absent some indication that the order is not being complied with, why would it be incumbent on anyone to revisit that original decree?
Well, because for one thing, from the Supreme Court down now, we're seeing equal parenting time with fathers and mothers. The father wanted equal parenting time in this case. He didn't get that. He got very limited time. So as soon as a year was up, he was in actually seeing me to begin the process of getting more time because he had the suspicion she wasn't living there.
Well,
then
Mr.
she gets
Charles,
filed.
Wasn't the evidence in the record before Judge Svoboda that notwithstanding the parenting time that your client got under the decree, which was every other weekend plus time during the week and time in the summer, that your client was not taking advantage of the summertime at all?
I'm sorry, you're saying he wasn't?
He wasn't. That was the evidence that I read in the record.
Well, the reason if he was limited, it was simply because the mother, they didn't live in a proximity, so he could exercise greater time. He has an 11-year-old daughter, if you recall from the trial, that lady said he's a great parent and I would give that daughter. And so there was no question he wasn't exercising, all going to events. These little girls were bonded together, meaning the daughter, Isabella, and the 11-year-old child. So I agree with you. There seems to be some implication of that, but it's only because she's in Rocky Point and he's here, and you don't have the type of parenting agreement with parents here. That's why I say it was so important for Judge Foster to realize there's going to be a long-distance thing to craft.
Well, what we're really talking about here, Mr. Charles, and I appreciate, I know you appreciate the difficulty with this, is we're really talking about the second judge's ruling in this matter, and it seems to me that we are not in a position to second-guess credibility determinations and factual findings that Judge Svoboda made.
Number one, I lose 100% of the time if I'm trying to balance on which is the better parent. Absolutely no question. But if you read, and I believe it's on page 23 of our brief, the Bates decision and then the older decision that talk about the aspect of fraud on the court. Quite frankly, I'm astounded. It was a fraud on Judge Foster. It had to have been. You can't have this lady testifying that she moved to Rocky Point in March of 2015 when a divorce trial was held December of 2013.
But what does that have to do with when your client is now in front of Judge Svoboda and the mother is asking for permission to relocate? Why is it now relevant if the parenting time was being complied with in between that and there's now a motion? Isn't there a clean slate and your client can come in and explain why it's not workable to allow mother to go to take the child to Mexico?
Yeah, I agree. A great question. Great question. I think because the father has two strikes against him when he sees Judge Svoboda. Number one, she's going to give integrity to the order. I'm sure she, like this panel, seems to be chagrined to tackle Judge Foster's order and to get to what happened there. Certainly she must have felt, and in her order seems to stress the same factors about the father. And as I suggested in Judge Foster's order, when you read it, it had to have been to some degree prejudice. I quote the findings that he made against the father. And it's carried over, I apologize, carried over in her decision, in my opinion.
Except, Mr. Charles, it seemed to me, in reading through the record, that clearly your client did in fact testify in front of Judge Svoboda, and she also had before her all of those exhibits, the emails, and the tape, if that's the right word, the video from the phone of the interaction at the gas station. So I mean, to me, my concern is even if we totally disregard what Judge Foster's findings were, which are a matter of record, and I think any subsequent judicial officer can take cognizance of that and rely on it. It seemed to me that Judge Svoboda had plenty in front of her to determine your client's credibility and make decisions in that regard. So again, it's not that we're chagrined about what we should or shouldn't do. I think we're required to give deference to the trial court's ability to observe the witnesses, make factual findings and credibility determinations.
I suggested to you I lose if it's a balancing. I do think if it is, and again, you know the standard abuse of discretion, the mother in this case, in the case in front of Judge Sabota, testified herself. Very limited testimony, basically to attack the father. Father brought in his former wife or former mother, his mother, himself, and there, if you look at Judge Sabota's order, she calls it the family, what do we call it? Family, the whole family doctrine. And I didn't catch that until preparing for this argument. There is a decision the appellate court has set forth on that, on Edwards versus Tolhurst, Tolhurst. That's 2014-0126 decision, which actually this court reversed the trial court when they used that as a finding, and it was a balancing act. In other words, when the trial court found for a single dad that the mother had remarried, moved to Texas, I believe in that decision, and the whole family, got the whole family, and Judge Sabota basically considers the whole family in Mexico. And by the way, one other last thing. Mother made a big deal at the trial, as you've read the brief, that the child's in this school. It's a great school in Rocky Point. That school is now different. It's a different school in Rocky Point. I mean, when my client told me the mother's living in Rocky Point, going to live in Rocky Point, and this is happening, I said, it's not going to happen. Yeah, her parents are here, you're here, the grandmother's here, everybody's here. It has happened. That's not justice based on what, and I'm sorry, again, I keep hanging on to what was told to Judge Foster. I think it's wrong to lie to a trial judge. I think that's highly inappropriate, and the base decision others says this court has the power to correct that wrong. Thank you. I'll save a few minutes.
Good afternoon, Your Honors. Patrick Sampier on behalf of appellee Cynthia Gutierrez. Frankly, Judge Winthrop sort of made my argument for me. The issue here is not Judge Foster. That hearing was held 3 years ago. A final ruling was made. Findings of fact, conclusions of law were issued in that case, and Dad never once filed a motion to set those things aside. It's totally disingenuous for Dad to come in and say, well, I never knew she was doing all these Mexico trips or even living there. That's not true. First of all, he had the emails every week. Second of all, Judge Foster made a finding that he knew that Mother was going to Mexico. I think Judge Foster's findings said frequently. So for Dad to come in and say, oh my God, look here, this just hit me over the head, I just found this out, that's just not true. It's been going on for years.
I'm
yes, sir.
Trying to understand Mr. Martinez's concerns. The way I understood part of his concern in front of Judge Foster was, my ex-wife is going to take my child to Mexico and I'm never going to see her again. And Judge Foster concluded, there's really not sufficient evidence to support that. Well, a couple of years later, it's happening.
Well, actually, it's not. The first part is happening.
And
she's going to Mexico.
I understand the visitation is in place, and Mom is fulfilling it and will fulfill it.
Right, and I think
I'm just saying it's not completely out of the question for Father to be upset. Not that I approve of the way he expressed his frustrations.
Well, we can all agree that that's not appropriate action. However, if you think about it, Mother did exactly what she should have done. She filed a petition for relocation. Father had every opportunity in that petition for relocation to make any arguments he wants to make. So I would agree with you, Judge, if Mother had gone to Mexico and just living there and never did anything and maybe even denied Father some of his parenting time, I think she should be punished for that. But she didn't do that. She filed a petition to ask the court to relocate. That's what you're supposed to do in family court. She did the civil right thing, which is, to be honest, far from what we can say about Father and some of his behavior. I think it's also important to note that Mother's proposal, both in her pretrial statement and during her testimony in court, is to give Father even more parenting time in the summer. I think that that's an important issue in this case because of Father's sort of suggestion that he's just losing everything with his daughter. He actually got more when he walked out of that courtroom that day. And I think that's important to note, too. The bottom line on this...
Make an explanation that might not work well with his schedule. Was there some discussion about
He never even raised it in the pretrial. Nothing. We offered it. Well, I'm not going to get into settlement offers. Bottom line is, it was in the pretrial statement. We testified to it at court. He never objected to it, ever. He never even raised it as an issue. He never even said he didn't want it or wanted it. He just ignored it. So, I mean, if he's going to stand here, figuratively speaking, today and tell the court, well, I really didn't want all that extra time, then why are we here today? The reality is that he got more time. And if he wanted the child 50-50, how could that not work for his schedule in the summertime? Because that's what he's arguing. I want 50-50 with the child. Well, that's what he got in the summertime. And he got it in part because my client offered that. So, the real issue here today isn't fraud on the court. The issue is, are the findings of fact and conclusions of law issued by Judge Svoboda consistent, first of all, with the statute, and they are. And are those findings of fact and conclusions of law supported by the facts in the case? And I don't think anybody could argue there's facts to support every single one of them. And are any of those findings of fact and conclusions of law clearly erroneous? And there's not even an argument about that. There's just this sort of side argument that, well, she was bad in this first case, so now we just can't let her have anything in the second case. And I think Judge Catani brought this up, the clean slate issue. Even assuming arguendo that mother did lie in the first case, in the second case, Dad had a whole new chance to make those arguments, and they failed. And there's no evidence in front of the court today that mother did anything wrong in the second case. The only argument that's being made is some sort of argument that frankly isn't even available, I think, on appeal, which is set aside or use some bad conduct that was never appealed or no motion filed in a previous action against her in this action, even though it's not even relevant to this action, in my opinion.
What if mother had not complied with the parenting time? It just stayed in Mexico and only came up
Well, I think that'd be a big problem.
Twice a year. What would the remedy be to go back and revisit the original decree, or what, in your view, what?
Well, I think the remedy would be several. First, Dad could file a petition to enforce, and Mom might find herself visiting former Sheriff Joe Arpaio's jail. Second option is that Dad could file something to modify file a petition to modify legal decision making and parenting. I mean, he didn't do that either. He filed a response to the petition Mother filed. So he has those opportunities, but again, that never happened. My client did exactly what we want our clients to do: obey the rules, obey the law, and when it comes time to change things, don't. Frankly, Mr. Charles has got a point. You go up to the 5th and 6th floor up there and you find people doing the wrong thing all day long, taking the law into their own hands, not letting parties see the children when there's a court order, these kinds of things. My client didn't do that. She did what the law required. And, I don't want to say that should be applauded, but I guess being old family law lawyers like he and I are, we've known each other for many, many years, we don't see it enough, to be honest. I'm sure you don't see it enough when they come up here on appeal. And so I don't think that there's a single thing my client did wrong. I don't think there's a single thing that the court could say you should have done the other way, because she did everything the law required. She even told the court in the relocation action that she was going to Mexico. She was very honest about that. She said over the course of the time between when we were divorced in March of 2014, yeah, my time in Mexico increased, and eventually I stayed down there more often than not, most of the time, if not relocated there. But Dad never lost his parenting time, and he never objected to that, not once. And so I don't see that there's any argument here in front of the court. I don't think the Court of Appeals can punish somebody for obeying the law, which is what exactly happened in this case.
He mentions that his client obeyed the law, and I suggested to you all, I've beat it to death here, she didn't tell the truth. Number two, I've tried to make it crystal clear, which obviously I haven't. The father...
You're disagreeing that she did not let Judge Foster know she was making trips to Mexico initially? You're just suggesting that she was planning to live there and didn't...
Absolutely.
But Judge Foster was aware that she was driving back and forth to Mexico.
He was aware of that, and she convinced him, I have a home in Buckeye, I'm working in Arizona, I'm not going to live there. Yeah, I'm pregnant with somebody's baby. Yeah, they're national there, but I'm not going to live there. That's what she told Judge Foster. My client relied on that. They had no dialogue with each other from the time of the divorce after that. He picked up the child. They exchanged the child. He had no idea that the lady was going to be living there. She carried this facade on regularly that she was living at her mother's home or in Buckeye. And the emails do not show coming from an international port. Emails don't show that. So it wasn't until he just kept suspicion what's going on, what's happening, that this whole opened up. And when the mother filed with another attorney, within just a little over a year, the modification, Mr. St. Pierre picks it up and says, basically, when you'll see his amended pleadings, this can't be a modification because of the circumstances I'm saying here. Look at the file record on this. You'll see that clearly it was a fraud on the court. So he says, so what? If you build a house on sand, it's going to fall, usually. And I'm suggesting that's what this was to Judge Foster. That's how this house was built. Not on the truth and integrity, but on it. And that's why my client was hurt at the trial level, because he was looked to be irrational and a jerk, saying that she's going to go to Mexico. And yet we know that in March, 3 months later, after the trial, she was living in Mexico. So who's the jerk in that situation? He lost his daughter. She lost the ability to live in Arizona. The parents lived here in Arizona, was raised here in Arizona. There was no question that they were going to live in Arizona. That was one of the other arguments. But I say I lose on the balancing it, unless you dig into that one case and find on the balancing, maybe the trial judge should have looked at some other issues. All right. I thank you all for your time and interest in this matter.
Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course. With that, we're adjourned.
Thank you.